morning, Mr. Longstreet.
Good morning, Mr.
Kelson, sir.
Mr. Kelson. How are you?
I'm well, sir. How are you?
Pretty good.
I'd like to talk to you about the finances of Rocket World that you mentioned on direct examination.
Yes, sir.
You testified that Ms. Bowman worked for your park starting in 2011, right?
Yes.
She was the ticket booth operator that year.
Yes, she was.
And then in 2012, she worked ride operations.
Yes.
Now, Mr. Longstreet, you testified to observing some problems with your finances and admissions system in 2012, right?
That is correct.
You didn't observe these problems in 2011, did you?
We didn't have any financial problems until WIT recommended that I hire her friend the following year, not 2011.
So when Ms. Bowman was working the ticket booth, you didn't have any financial problems?
No.
Now, Mr. Longstreet, when you did notice those financial problems, you suspected they were coming from the ticket booth, right?
Yes.
You suspected specifically that the problem was with fake World Tour wristbands.
That was my hunch, yes.
And eventually you fired the ticket booth operator, Cameron Poole, based on that suspicion.
Eventually, yes, he was terminated from Rocket World.
Now, Mr. Longstreet, like we've covered, Ms. Bowman did not work the ticket booth in 2012, did she?
No, she did not.
You never observed Ms. Bowman handling World Tour wristbands that you believed to be fraudulent?
I don't know if she was doing that at all, no.
You never observed her doing that?
No, I don't know if that's what she was doing.
You never overheard Cameron Poole and Whit Bowman discussing World Tour wristbands?
I do not know if they had those conversations.
You never overheard any?
No.
Mr. Longstreet, I'd like to talk to you about August 30th.
Okay.
You mentioned that there was some sort of incident at the ticket booth that evening, correct?
Yes, my ticket booth operator was robbed.
You approached your ticket booth operator, Ms. Floyd, after this incident?
That is correct.
And Ms. Floyd said some things to you in a state of distress, right?
Yes, she told me Whit's friend had come back to the park after he was fired. I put a knife to her face, threatened to carve it up if she did not give him all the money she had.
Mr. Longstreet, Ms. Floyd didn't say Whit's friend, did she?
No, she explained to me that it was Cameron Poole.
That's right, Mr. Longstreet. Ms. Floyd said Poole approached the ticket booth,
Yes,
right?
Cameron Poole was Whit's friend. I'm sorry.
In fact, Ms. Floyd didn't mention Whit Bowman at all.
No.
She didn't mention.
She mentioned Cameron Poole.
She didn't mention that Whit Bowman approached the ticket booth.
No, Whit Bowman was out of the rides.
She didn't mention anything about Whit Bowman.
No, she said Cameron Poole had robbed her with the knife.
She didn't mention that Cameron Poole had said anything about Whit Bowman.
I don't believe she did, no.
Mr. Longstreet, I'd next like to talk to you about Whit Bowman's job, about ride operation at Rocket World.
Okay.
Mr. Longstreet, you are the owner and CEO of the park, right?
That is correct.
So safety training is ultimately your responsibility.
To train, we actually have people from OSHA come in and train them.
But ultimately, sir, the responsibility for maintaining safety in the park is yours. The buck stops with you.
It's my job to make sure that all my employees are trained properly.
To that effect, Mr. Longstreet, you and Ms. Floyd maintain an employee handbook for your park, right?
Yes.
This handbook accurately reflects the training that's given to your employees.
It tells them the do's and don'ts.
And that handbook is regularly updated as your employee training changes.
Yeah,
Mr. Longstreet, you would recognize that handbook today, wouldn't you?
I should, yes.
Your Honor, let the record reflect I'm showing opposing counsel what's been marked as defense A. You're welcome. May I approach the witness?
Yes, sir.
Mr. Longstreet, that is Rocket World's employee handbook, right?
Take a second to look through it. Yes, seems to be.
That's the most updated copy of this document.
Yes.
Your Honor, at this time, the defense offers Exhibit A into evidence.
Any objection from the state?
Yes, Your Honor, to hearsay.
Any response to the hearsay objection, Mr. Kelson?
Yes, Your Honor, this document falls under the hearsay exception 8036, a record of a regularly conducted activity. Mr. Longstreet has testified that this is a record of the regular activity of training his employees, that he and Ms. Floyd are the custodians of this document, that it is regularly updated as their training changes, and that it's kept in the course of the regular business of Rocket World.
May I respond to that, Your Honor?
Go ahead.
The witness stated that this is a document of do's and of don'ts. It's commands to the ride operators and to employees. It's not a document that contains records, so it's not it does not record anything specifically made at or near the time of any sort of business activity.
Mr. Kelson.
Your Honor, documents like employee manuals and like this one specifically record acts. This witness has testified that the information in this document is consistent with his action of training his employees for some specific circumstances. It records and reflects the act of that training.
Ms. Hedgel, I certainly appreciate the specificity of your objection, and do you have any case law that would support your contention as for your interpretation of the business records rule?
No, Your Honor, just the definition of record within the rules of evidence themselves. If you turn to 101B4, it said it includes a memorandum, report, or data compilation. And that is the definition of report given in these rules in this jurisdiction.
Mr. Kelson, do you have any case law on this issue?
Your Honor, I don't believe we have any pertinent case law for this case on this issue. However, pursuant to the definition cited by counsel, this document falls under a category similar to a memorandum. It records an act.
What act does it report?
It records the act of Mr. Longstreet and his fellow management training their employees. He's testified that this is consistent with the training they receive and is updated as the training they receive changes.
Given the interesting way the rule has been written in this jurisdiction and given the absence of any case law, the fact is we have a valid hearsay objection and no refuting case law that I can rely on. So under these circumstances, I feel constrained to sustain the objection, and so that will be sustained.
Certainly, Your Honor. May I retrieve the document from this witness?
Yes, sir.
Mr. Longstreet, I'd like to talk to you about your job at Rocker World.
Okay,
You are the owner and CEO of the park, right?
that is correct.
Now, Mr. Longstreet, you testified that Rocker World hadn't had financial problems before 2012, didn't you?
Yes, that is true.
That's actually not true, Mr. Longstreet, is this?
Very true.
Mr. Longstreet, Rocker World was investigated for tax evasion in the past, wasn't it?
Objection, Your Honor. It's improper character evidence.
Response, Mr. Kelson.
Your Honor, this is not being offered as to character evidence. This is being offered as to this witness's character truthfulness under Rule 609. It is, if I may proceed, this will go to show evidence of a past criminal conviction that is admissible pursuant to that rule.
Ms. Hedgel.
Yes, Your Honor. This tax evasion charge that opposing counsel is talking about is simply a case of misfiled paperwork when Mr. Longstreet took over the park over 12 years ago. Rule 609B actually gives a limit on the evidence that may be used, and that limit is 10 years.
May I be heard on that point, Your Honor?
Go ahead.
The specifics of the crime and the specifics of the circumstances for the conviction are not material to this rule. Counsel is free to inquire about those under redirect examination if she believes they're pertinent. With regards to the time limit, that rule sets out an exception under 609 subsection B for that 10-year time limit. Specifically, the time limit is that if specific facts and circumstances point that this evidence of past conviction is substantially more prejudicial than probative, it may be admitted. This conviction involves a dishonest act, and Mr. Longstreet is testifying about the financial conditions at Rocker World, the same conditions that he was dishonest about in the past.
So the parties have agreed then, it sounds like, that there was in fact a conviction, but that conviction was more than 10 years ago?
That's correct, Your Honor.
That's correct, Your Honor. I believe that's not a contention.
Well, given the rules of evidence that apply in this jurisdiction, I would have to find that the probative value would substantially outweigh the prejudicial effect, and there is a pretty substantial prejudicial effect that comes into play when bringing up witnesses' prior conviction. So given the length of time that has passed here, I cannot find that the probative value would substantially outweigh the prejudicial effect, and so I would not allow that testimony.
Certainly, Your Honor. So counsel's objection is sustained at this
Counsel's
time.
objection is sustained.
Your Honor, move to strike that question from the record.
Granted.
Mr. Longstreet, I'd like to talk about safety at Rocker World.
Yes, sir.
There have actually been safety problems in the past in the park, right?
We have had one or two accidents, yes.
The park doesn't have the most up-to-date safety and security features.
A lot of people like to say that, but we've passed all our inspections, so I would like to think so.
Mr. Longstreet, you've said that the park doesn't have the most up-to-date safety and security features.
Well, we're not in the 22nd century or nothing like that. We're a pretty basic park, so, but we do meet the guidelines and have passed all our inspections, so.
Mr. Longstreet, was that a yes to my question that the park's not the most...
We don't have the most advanced technology, no, but we have passed the inspections.
Mr. Longstreet, that lack of up-to-date safety and security features has led to a few injuries in the past, right?
We've had some minor injuries at our park before, but nothing major.
So there have been injuries at Rocker Roll in the past.
Yes.
Thank you, Mr. Longstreet.